here in person. I think it's a great turnout for in-person CLE, and I know we've got a number of folks online. I am not going to try to introduce these three wonderful people who have volunteered their time to talk to us today. I don't think they need much introduction for all of y'all. So I just want to thank all of you on behalf of the Lee County Bar Association for being here today. Thank you to the judges for volunteering your time. And without further ado, we'll let them get started.
Okay, thank you. So I'm going to start off with an introduction, and I'm going to kind of talk about how we got here and kind of the purpose that we got here, a little bit more of a big picture as far as the civil change and how it came about. And truthfully, a lot of this began in the 20th Judicial Circuit. The foreclosure crisis hit, 2007, 2008, 2009. At one point, we had 32,000 pending foreclosure cases in Lee County. When you talk about 6 judges handling, or 5 judges at that time handling foreclosure, we each had over 6,000 foreclosure cases on top of our regular docket. And what we realized is that we had lots of cases that were just kind of out there in the world that had no court date, that no one was really doing anything on, that were just kind of escaping the system. And so partially as a reaction to that, but partially just because we thought, based on the rules, we have an obligation to case manage, we became the first circuit to begin differentiated case management within the state of Florida. And that was back in about 2012. And so while the rest of the state moved to differentiated case management as a result of Chief Justice Kennedy at the time, administrative order in the pandemic, we were ahead of the curve, and quite frankly, our system was the model of what he implemented statewide. So that really wasn't a big change for us. What was a big change before he did that, he had implemented a work group within the Judicial Management Council to take a look at civil rules and changing civil rules, because the thought was, and the reaction that he was getting back, not only from attorneys, but from businesses, from individuals, was that our system had become somewhat archaic and fallen behind what other jurisdictions in the federal courts were doing. And so he wanted the work group to take a look at that and come up with recommendations. And Judge Morris from the Second DCA led that work group, and I was on the work group, and his motto throughout that was, what we do is not controversial, we are not doing our job, because we should at least make controversial recommendations for the Supreme Court to think about, and they ultimately will either put them in place or not put them in place. And so ultimately phased in over a number of Supreme Court decisions, these rules have now been implemented and have come to kind of full fruition as of January 1st. And it is a seismic change in the way that we practice law and the way we practice law going forward. None of it is really new. It's borrowed from either federal court, other states, et cetera, but it's new to us, and it's a huge change for what we've done. And so that's kind of how we got here. Big picture, I think Lauren's going to talk a little bit about what we're doing based on the rule change of January 1st here. So
what happened is, you may know that the Supreme Court has issued several opinions. The most popular one is December 5th. There's an original one, and then there's a corrected one. And then just last week, the Supreme Court issued another order changing a few things, a few strike groups and things like that. So what we've done is we've convened a committee, and we tried to come up with a case management plan, which I'll address later on, that will be adopted by an administrative order from our chief judge, which will be required for all county and circuit civil cases as of January 1. It will have a plan attached to it. There'll be no more agreed case management plans, and it's a whole new way of operating. What the Supreme Court has done is spoken to all of us, and they're making it a professional obligation for us to conclude litigation as soon as possible. So what they're doing is they're making all kinds of new rules that the lawyers have to comply with, and all new rules that the courts have to enforce. And the best advice I can give you is read the rules, read the rules, read the rules. And you'll hear more during my next segment. Thank you.
I was just going to say, I've been giving these at 12:30 on Zoom. If you want to hear more about it, it would really need to be more summarized than what we're going to do today. But if you email my assistant, Kim, I will give one of my half-hour talks on all these rules to any group. And I've done it for probably 1,000 people now over months. Some smaller groups. This week was just a few, and sometimes it's 200. So if you want more, or if you want to hear it again, that's available. Just email Kim. And I would just tell you, I started my preparation by reading, a Court of article that said they're worried about lawyers getting sued and getting reported for malpractice and bargaining. Because if we don't change, I've been saying since the pandemic, since 2020, I was the civil judge July 1st, 2020, in Charlotte County. I said, we can't practice law like we have, like I did my whole career. And then we got the tort reform bubble. And I said, for different reasons, we can't practice law like we have been doing. And then we got multiple hurricanes. I got in Charlotte County as the only civil judge, thousands of cases. And I kept saying, we can't practice law like we've been practicing. And now the Supreme Court said, ready or not, we're not going to practice law like we have. So I really need, for those reasons, you really need to internalize these. This is no substitute for reading the rules, but we're going to give you the once over. All right. So next, I think I'm next, right?
Yeah.
All right. So I'm going to go over some of the less involved rules that I think will impact your life less. I'll start with the rule number and then tell you what sort of summary. Rule 1.090 time. Case management orders are amended as provided in the case management rules. 1.200 is the regular rule, and then 1.201 is the complex. Trial continuances have been shifted over totally to 1.460. If you want a continuance, we'll go over that. There's a list of deadlines that cannot be extended. And I'm not sure this is a radical change, but there's two types of extensions. One that's filed before the deadline and one after, which requires excusable neglect. The one filed before the deadline has this wrinkle in it that I don't remember that seems to say maybe we can grant things without a hearing. Do you agree with that?
As long as it only affects one.
One deadline.
Yeah, so some of this is new and some, I think there's going to be litigation about these things. So, by the way, we didn't really say, we're gonna take questions at the end. We wanna make sure we get the information then. So if you have a question, make a note of it and we'll come back. Rule 1.110, general rules of pleading was changed in a different order from last year. I pointed out because it's how I practice and what I've required in my court, and it probably wasn't fair at the time. If you have an affirmative defense, it has to be state the affirmative defense and a short, plain statement of facts. Just saying there is negligence, just saying, whatever isn't enough. In an insurance case, what that means to me is to cite the policy provision and a short, plain statement of facts that trigger that policy provision. So I think all of these things are trying to front end work and make it more efficient. So just take a look at that. 1.202, conferral prior to filing motions. That's the other 12.5 order. When you file a motion, there's a bunch of exceptions that you don't have to confer on, but if it's not accepted, you have to confer. And you have to look in the rule, there's a certain certificate. If you file the motion, since first you're supposed to have that certificate about what you did. I suspect my brothers and sisters don't have any magic numbers for you. What's a real conferral? I'm going to just start paying attention, close attention. If you say, look, I sent the conferral, I sent 2 emails, 2 calls, nobody returns my calls or emails. Do you think that's going to be sufficient just to not, So you have to certify. Under the complex rule, you have to confer 15 days before case management hearings or other hearings too. So all motions not accepted, you have to confer, you have to restrict it in the motion, which means you have to talk before you file the motion, which is a big change. Purposeful evasion, withdrawal sanction. I don't know what that means. They didn't say. How you implement it will be up. That's sort of the art of being a trial lawyer. How you confer with somebody about something you haven't filed, right? You have to confer before you file it. So good luck with that. Hearing procedures. The first one of these I did for 200 people. One of the lawyers was actually yelling at everybody and said this. What happens to you if you don't do your job? He was very upset. And I said, well, I get impeached. I can lose an election. I can be brought up before the Supreme Court and any number of things less than losing my job can happen to me. Because really the focus is what happens if you don't confer, right? What is purposeful evasion? I think we're going to have to feel those things out. I think one of my messages across all of these things is know your circuit. We're going to have an AO and orders and know your judge. Right? With me, don't mess around. Return the calls, return the emails. Right? This is a July 1st change that I have had multiple hearings about. Non-binding R board. If you want to reject a non-binding R board, this changed last July. Some of you followed my order from before July and filed a trial de novo request. The new order as of July 1st requires three things. Rejection of the non-binding award, a request for trial, and that's being one document. Please do that. This is something that's been in place for months. So I think Lauren's doing the case management, right? So one of the ways, tools that we have to have litigation reflect the needs of the case, I think, is putting a case on inactive status. The inactive status rule says if you're in inactive status, bankruptcy, appraisal, there's reasons to go off in the world. Will get you an inactive status and extend the deadlines of the case management. Right? So that is a way the file will reflect what's really going on for your case. Oh, this is a personal peeve of mine. Everybody write down your notices of hearing are supposed to say the name of your motion and the date it was filed. And also the order is like 15 years old. It also says the docket number, because they used to bring, before I was in judge, they would bring these folks the paper files, but it would say tab 23, and so you look for the docket number, right? But now I just need the date. So please look up the administrator 2.35. If you do your own notices of hearing, make sure that they have the date of the motion was filed. Name of the motion. If I get so many notices, motion compelled cases 18 months old, there's 37 motions compelled. I think it's the most recent one, but I don't know. So please comply with 2.35. It's been in place since 2013, and I still have to talk about it every month. So, all right, I think that's the end of my rules, and now we're up to Ms. Brodie for case entry.
So 1.200 is the case management pretrial procedure rule that's been enacted. This is only for new case management plans for cases filed after January 1 of this year. Any extension to the old plans, we will not be changing the old plans whatsoever. The old plans remain in effect. However, any of the rules that apply to extensions or anything else do apply to the old plans. So you're going to have to familiarize yourselves with those rules, you know, what works and what doesn't work and what applies. And so do we, because obviously we're going to have to look at every case and say, is this governed by the old plan? Is this a new plan? So there are going to be different rules in effect depending on when the plan was filed. The 1.200 specifically lists 18 exemptions for when the requirements of this rule do not apply. So you might as well look at those. But for general cases, they're going to either be assigned probably a track and a case management order. They'll be streamlined or they'll be general. And the rule specifically sets forth what that means. So the rule says streamlined are cases that reflect some mutual knowledge about the underlying facts. They have limited needs for discovery, well-established legal issues related to liability and damages. You anticipate dispositive pretrial motions, minimal documentary evidence, and anticipated trial length of no more than 3 days. So all county civil cases will probably be getting a streamlined case management plan, as will certain types in civil, in circuit civil. Complex.
Know your circuit. There are circuits on the East Coast that their AO is going to say any first-party homeowners insurance case is streamlined. I've seen the orders. We've all seen them. Some counties that are circuits are going to say a homeowners, which wouldn't, not every one of them would fit any of those items, right? So no, you got to know your circuit. It won't be the same everywhere. But what's streamlined? If you check in your civil, what's the civil cover sheet? Insurance, some of those circuits are going to make you streamlined. Go ahead, sir.
We're going to have presumptive tracks initially, but they're going to be revisited, obviously, because an administrative order is going to be issued in the next week or two. We're just working on that, and Judge Porter is going to do that. And that will require the case managers in our circuit to issue case management plans for either general or streamlined. The rule often also says that if you want to change the track, if you know for some reason that it's going to be complex into 1.201, then you're going to have to file a motion before the court, and then there are going to be certain rules and requirements for that. And we're not going to be doing that very generously. So that's something that you have to be familiar with. The Supreme Court has also dictated what has to be in our case management plans, and there are different categories than that which have existed in the past. So now we have to put in a date by which you have to file the motion for summary judgment, a date by which your motion for summary judgment has to be heard. There's going to be a provision for filing and resolving all objections to pleadings. there's going to be a provision that if you haven't set a hearing within, let me just, 60 days from the filing of the motion or objection, it's going to be deemed abandoned or denied. We're all going to be required to move cases. So when you file a motion, please make sure that you obtain a hearing date and make sure it's within that 60-day time period. Also, judges are going to be opening up more hearing time. And if you're having problems getting hearing time, call or email the judge's office, because we're all under these same requirements as you are, that we have to provide hearing time to make sure that these case management deadlines can be complied with. So we're all in the same boat together. So please make sure that you set things and that you operate promptly. We have to assign a draft and case management plan no later than 120 days from the filing of the initial complaint, regardless of service. If you add a new defendant or a new party down the road, you're going to have to serve them with this case management plan at the time of service, because there's no way for them to have gotten that. And they have to be on the same page at that time. So please make sure you do that. The other thing that is going to be important, I think many of you know this, is at least in Collier, we've been having a mandatory status conference, and we've now changed where that's positioned on the case management plan, because that's going to be right up front. So have your staff calendar the mandatory status conference date, as well as the pretrial and trial period. I will tell you, in a few minutes, I'm going to go over the new pretrial procedures, and they're going to be much more cumbersome on all of us. So we may have to allocate more time for pretrial conferences. What that means is that the date and time that will be in this case management plan may be changed closer to the actual pretrial conference. So please educate your staff to be on the lookout for an order closer to the pretrial conference date, because otherwise you'll be sitting on Zoom for hours when your pretrial conference time may have actually been changed. So that's important to note. There's deadlines now for motions in limine for depot designations. So all of that is going to be spelled out in the case management plan. Please make sure you familiarize yourselves with them. They'll all be circuit-wide, but there'll be certain differences for each judge. So these will be adopted by the administrative order, but then you have to learn, if you heard, about specific judge, specific requirements he or she may have. There are specific rules in this new 1.200 that talk about how you can modify deadlines. And there are different requirements for if there's a projected trial date versus an actual trial date. We anticipate issuing trial orders shortly after the case management plan, which will establish the actual trial period. That way, when you're reading the rules, you look at those rules that govern when you have an actual trial period. Okay, other circuits like Geoffrey may have projected trial dates, and I don't know when they will get their actual trial orders out. So every circuit is going to be different in that respect. If you want to modify deadlines, amending case management plan, those are only going to be heard by the assigned trial judge in Collier. I don't know what the Lee or Charlotte judges are going to do, but it's not fair to have them heard by the general magistrate, because then you have the exception period and everything else, and it doesn't help comply with the time requirement. So we just had a meeting yesterday, and the 3 judges in Collier have all, well, 2 and the unassigned one, have all decided that we're going to do that. So that way it'll help us. It'll be putting more of a burden on us by giving hearing time, but we figured that will be better in the long run in order to make sure that we comply with the time requirements that set forth in this new plan. Once the trial period is set, only a motion to continue under Rule 1.460 can change that. So please make sure, and that actually spells out what has to be included. It can no longer just be a motion to continue and find consent. There are specific criteria that has to be set forth, and the order also has to say whether the motion and the order that the judge signs is going to have to say whether further activity will be permitted, and if so, what that activity will be. The other thing is in 1.200 sub 3, where it talks about modifying a deadline or a case management order. Again, there are 4 criteria that have to be met with specificity. Make sure your motion complies with that. That's going to be something that will be enforced. The other difference is now that obviously some of you routinely ask for a case management conference before different judges. You would have to now include what issues have to be addressed and what pending motions you want heard. So That has to be done. Now, if a judge wants to set a case management conference, then be prepared to hear not all non-evidentiary motions, even if not always noticed. So be prepared. You're going to have to, the whole purpose is to get motion heard and get the case moving in order for us to comply with these new requirements in the time series as outlined in the rules of judicial administration as well as this particular rule. At the conclusion of the case management conference, the court is now going to have to set a deadline for the parties to submit orders. And you're going to have to submit an order by that date. If there are competing orders, please make sure that if you are submitting a competing order, you state specificity in the cover letter, what you're disagreeing with. And that also has to be done in a timely basis so that the judge can issue the order on the case management conference. As you've heard, the new rule contemplates that if you have a trial date, you can only move one deadline in the case management plan. If you want to move more than one date in the case management plan, you have to file a motion before the judge regarding amending the case management order. So please familiarize yourself with the requirements of these rules. Now, as far as the pretrial conference order is concerned, I think it's a little different. At least on Collier, we're not, and I don't know, I haven't confirmed with everyone, you can no longer avoid attending a pretrial conference by submitting the pretrial conference order. You should be following the pretrial conference order 7 days in advance of the pretrial conference. And now there are certain rules that have to be set, certain things that have to be contained in it. So they're contained in sub K of 1.200, and they include having jury instructions and verdict forms finalized. So a lot of times people wait until between pretrial and docket sounding or even right up. But this rule now talks about everything that has to be included. So I would suggest that you look at those rules that have to be addressed and make sure that you're ready. That's why it may take more than 1 or 2 minutes at a pretrial conference now to say, oh, you ready for trial? Because now the judge is required to go over these issues. And there are many of the issues that are typically contained in the pretrial conference order. So I would suggest that you look at this rule and make sure, and again, there's a conferral requirement. And for me, conferral at all these different junctures means in person, by phone, or video conference. I'm going to adopt what the federal standard sort of is, so that it's not a question of exchanging emails. Emails don't work. Having assistants contact each other, that doesn't work. I'm going to interpret this as requiring the attorneys to pick up the phone like the good old days and talking. It's amazing what happens when you talk to someone, you know, and especially if you meet someone in person and talk, you know, realize that before COVID, we all saw each other in the courtroom, in the hallway. You had an opportunity to talk and resolve issues. That has been eliminated by Zoom. And Zoom is here to stay, but we have to get back into the conferring and talking. And it's amazing because sometimes when people show up on Zoom and they haven't spoken, I'll say, have you conferred with the judge? No. Well, now you have a duty, not only to confer before you file the motion, but also a duty to confer before the hearing. And there are going to be sanctions if I find that people haven't conferred, because that's a duty that's now being imposed on you by the Supreme Court. And I expect you as professionals to follow that. And I'm preaching to the choir. I'm talking about the people who you interact with, but you can be the good stewards who show people how we act and what the rules require. The other thing is, I think I told you this, so I think I'm good.
Are you?
Yeah.
All right.
I hope that was enough information, just my 10 minutes or 15 minutes, but thank you.
All right, next we've got Geoffrey McHugh on discovery related issue.
Okay, so yeah, I have rule 1.280, which strictly probably could be a day-long seminar just on its own. A couple things I want to touch on briefly, because it kind of came up when Judge Brodie and Judge Gentile were talking. A couple things. One is the Supreme Court indicated when they first accepted the rule changes for the first time that they were going to do this in stages. And they did. They did case management first, and then they did a lot of these other rules later. Some of the other requests that the Judicial Management Council recommendations made was the judge's ability to rule on motions without hearing more freely. And there was a procedure that was outlined in order to do that, which is a little bit more in line with the federal courts and what they have the ability to do. And so I'm not sure whether they didn't accept that or that might be the next phase. And so I'm putting that out there because I know that discussion came up. Also, us as judges in regards to this now do have a reporting obligation, meaning that the Supreme Court gets the ages of our cases, how old they are and how many are certain ages. The idea being, okay, if you as a judge have a disproportionate number of old cases, you maybe aren't doing something right. As far as moving your case forward, or maybe, you know, if you're obviously in a complex business division in Miami-Dade or Orlando, probably the expectation is you would have cases, et cetera. But there are ramifications to us in regards to our caseload and how we handle it. 1.280 changes discovery incredibly. When you look at it, I mean, historically, the whole idea between with discovery, or the rule was, you know, it has to, you know, be reasonably lead to, you know, discoverable or admissible evidence. That isn't the rule. First off, there is now mandatory disclosure up front, and if you look at 1.280, at the very beginning, A1 and then A through B lists what the obligations are in regards to that mandatory disclosure. And it's all of the stuff that generally we would provide in that initial set of interrogatories and requests to produce that information, witnesses, what they would testify to, contact information, any information pertinent to a claim or defense, insurance policy, et cetera, mandatory, upfront, 60 days from service or joinder. The obligation is that is handed over to the other side. Throughout these rules, not just discovery, but all of them, is this whole idea of bad faith non-disclosure, and that is sanctionable. And also that boilerplate responses aren't allowed. And so when you go through these discovery rules, it is within that. And so a couple of the languages within the rule that I think it's important that I point out and read to you, because I think it's very important to know, is Rule 1.280, general provision concerning discovery, governing discovery. And then if you look at A4, and it talks about the unacceptable excuses and objections in regards to that initial discovery. And it said a party must make its initial discovery disclosure based on the information then reasonably available to it. And so it doesn't say what you have, it says what's reasonably available to you. So you can't not get something or say, oh, I didn't have it, so I don't have to provide it. If it is reasonably available to you, you have an obligation to get it and to provide it to the other side. And then it goes on and says a party is not excused for making its initial discovery disclosures because it has not fully investigated the case or because it challenges the sufficiency of another party's initial discovery disclosure, or because another party has not made its initial discovery disclosure. So you can't say, hey, I filed this lawsuit, I really don't know anything about it, and therefore I can't give you anything. The obligation is that you actually have done your investigation, that you have the information, and that you're prepared to provide. And so simply saying, yeah, someone walked in the door, they had a suit, I filed it, I haven't started yet, is not going to be an excuse in regards to that initial investigation and the information that you have to provide. And you also can't say the other side hasn't provided their stuff, so I'm not providing mine. That is not an excuse either. Us as a court need to deal with that non-disclosure by that other side, but that is not an excuse for you not to disclose. Then it goes on to say a party who formally objects to providing certain information is not excused for making all other initial discovery disclosures required by this rule in a timely manner. And that's another thing that kind of pervades these discovery rules. If you are objecting to a portion of what's being asked of you, great. Don't provide that, but that doesn't give you a boilerplate not to give anything in that category. Anything that you aren't objecting to, you have the obligation to turn it over, regardless of the objection to other information within that. And then the scope of discovery. The only part of our recommendation that we didn't recommend from the Judicial Management Council, but that the Supreme Court instituted anyway, was proportionality. We did not recommend proportionality from the Judicial Management Council. And there is a long discussion in regards to practitioners, et cetera, and a number of the practitioners, Mr. Edwards and a number of Mr. Hawkins, et cetera, who actually wrote objecting to it when it was in front of the Supreme Court in oral arguments, were on our committee and objected in our committee. And we had, very long discussions in regards to it. We ended up saying, we're not going to recommend it. They put it in place. And if you look at the opinion, 6 out of 7 of the justices agreed. And there was, Labarga wrote a dissent in regards to proportionality. But it's very important that you read proportionality, because that kind of changes the whole basis of discovery, because now the rule that I talked about as far as reasonably, calculated to lead to evidence is that the rule is parties may obtain discovery regarding a non-privileged matter that is relevant to any party's claim or defense and proportional to the needs of the case, considering the importance of the issues at stake in the action, the amount in controversy, the party's relative access to relevant information, the party's resources, the importance of the discovery in resolving the issue, and whether the burden or expense of the proposed discovery outweighs its likely benefit. Information within this scope of discovery need not be admissible in evidence to be discovered. And so if you have an action that's over $25,000 and you want, electronic discovery that is going to take, hundreds of hours to put together, you're probably
I don't know. Yeah.
concerned by a number where do you draw that line, how do we make the determination, and all of those types of issues. And that's what Justice Labarga talked about in his dissent. And what the majority said is, hey, look, we have a whole plethora.
I don't know. Let me see.
Specifically adopted federal law in regard.
Yeah, so quick assist app. There we go.
I think that's something to be aware of, because I can see probably a decent amount of litigation in regards to it, particularly on the front end. And where we as the judiciary draw that line, I guess we'll see as we go forward. So take a look at that. Another interesting rule associated with it, sub F of 1.280 requires that you cannot do any other discovery until the initial discovery has been completed. All right, and so you still have, the ability to do interrogatories, request to produce, and all the other, but you can't do that until the initial discovery is done. Another interesting portion of it is sub K, which requires attorneys to sign all discovery responses and basically say, hey, we've looked at this, and based on the rules, it is compliant, and we are attesting to the fact that it's compliant, so that when someone alleges that, you objected to this, but this wasn't objectable and you didn't hand it over to us and you should be sanctioned because we had to file the motion, then basically you have attested. All of these rules have a couple things in them. One is it gives the court the ability to sanction for noncompliance, which was kind of in there before, but it's much stronger now. And also has some language in regards to it that sets up an except by court order, meaning that some of these can be changed if you get a court order, but the reality is, unless you have a very different case, in all likelihood, these are the rules you're going to have to follow. Another thing, the same cases that are accepted from the case management plans are also accepted from these discoveries. And so those types aren't used. Okay, so that's 1.280. Read that rule because there's a lot in here I didn't cover, just didn't have time to cover, and I have a couple other things in my time that I'm supposed to go over. Next is 1.350, which is production of documents and things. If you look at that rule, once again, along the same lines as there is now a requirement that you be particular with objection. And so if you are going to object to these requests, sub 6 within the rule, B6 says an objection must state whether any responsive materials are being withheld on the basis of an objection. An objection in part of a request must specify the part and permit inspection of the rest. And so kind of along the same lines that we talked about before, is that if you object to part, You have to give the things you aren't objected to, but you also have to say whether you actually are withholding anything as a result of an objection. Because I can't tell you, and I'm happy about this rule, the number of times I get to a motion to compel or a motion on objection, they come in and they argue about the objection and whether it's appropriate or not. I'll rule, I overrule the objection and say, well, objection, you don't have any document. And it's shocking that happened, but it in fact happened, and that is why that was put in here. If you are withholding documents as a result of an objection, you need to actually say it, which I think kind of goes along the line. They want you to actually look at it beforehand, because I think the idea is a lot of people are responding to these without looking at the documents that they may or may not be handing over. They're simply saying, oh, that's a bad question, I'm going to object. Well, okay, but are you actually not providing something as a result of that objection or not? And so I think that is something that is important to keep in mind as you go through. One other point I wanted to point out, or one other rule that I'm going to go through, is Rule 1.380, which is the rule that talks about failure to make discovery and the sanctions associated with it. And so, if you look at it, it indicates that any party who failed to make the initial disclosure can move to compel, or the other side can move to compel and ask for appropriate sanction. And so within the rule, it specifically outlines the court's authority to sanction. And it's interesting because whenever anyone ever asked me to force someone to do something or sanction them, my question always is, what is my authority to do? And a lot of times there is none. And most of the things because you deal with it all the time, but whenever it's something unusual or, hey, you want me to sanction it, what is my authority to do it? These rules specifically outline it almost in every instance, the ability of the court to make appropriate sanctions associated with it, and normally say must sanction. And the idea is if you answer questions inappropriately, don't follow the rules, whether you call it sanctions or whether you call it, shifting of the fees, the idea is the person who caused us to do this litigation is the person who should bear the cost versus the side who is acting appropriately and simply trying to go forward. So if you look at the rule, if you look at 1.380, it talks about that. It goes into pretty much detail. Like I said, it almost always says the court must require the losing party to pay attorney fees and costs. And so the hope is with the requirement that you actually talk about any motion before you even file it, that you should keep this in mind, that if you don't agree with the other side and you go to hearing and you lose, there is a good likelihood that you're going to have to pay for that hearing. And so it gives you kind of that last out before you actually appear in front of the court, and potentially that fee is going to be assessed. So that's the end of my discovery part. Read the rules, because they are substantial changes to what we're doing.
And the fee is paid by the party or by the lawyer, because you're gonna have a lot of unhappy clients that the party is gonna have to pay.
The rule all says must sanction. It doesn't necessarily, it's not like the 57-105 where it talks about the splitting of it, et cetera. So I think unless it rises to a 57-105 level, then it's, just sanctions like normal sanctions.
So I'm gonna follow up something that Judge McHugh just said, and then we'll go to my subject. So you have to disclose, initial disclosure, and you have to supplement.
Yeah.
And the supplement is very interesting because it says unless otherwise disclosed. So I always use the example, I have a red rubber ducky on my dash that I got from my daughter to drive. So I have a red duck on my Jeep. And if somebody didn't disclose it, I don't supplement it, but every single deposition, we talk about the red duck. Don't follow it for sanctions.
Right.
But I don't know why anybody here would do that. Tell them about the red duck up front, if you know about the red duck.
And I'm glad you brought that up, because supplement is something that obviously is different in Florida. When we went through this, we had great people at the state court administrative office who looked nationwide, federal court, state courts, gave us rules from every state. Florida was the only jurisdiction in the United States that did not have an obligation to supplement your discovery. The only one. That actually you have to keep asking over and over again if you wanted anything new. Every other jurisdiction has an obligation that you supplement, which makes a lot of sense. Within this rule, it also has unless it's purely for impeachment. All right, and so if the information that comes is purely for impeachment, there isn't an obligation under those rules. Now, whether someone, actually does a formal request, through interrogatories with question for, you can talk about that and what's required from it, but there is a carve out for that, but there is a obligation, and it's not a specific time, and I don't have it, it's like reasonable, like a reasonable standard as far as the amount of time in which you have to supplement, but if you plan on using something, you better have supplemented it and given it to the other side, because you can't show up at trial, oh, by the way, we got all the medical records, or we got the estimates, and, I did give them to the other side, but here, I want to, and it's not gonna work.
The other thing I would say following that is, we talk about sanctions. One of the sanctions in this group of rules is you can tell the jury. I don't know what we're gonna tell the jury, but there's a provision to tell the jury about the breaches. I mean, we specifically don't litigate discovery in jury trials, but this is now in there. So the sanctions include, financial sanctions and right, Mike? It's also, we can tell the jury. I don't know if we're gonna tell them.
And I think the idea behind that is it's stuff that they find at the last minute that could have been used by the other side, and now they really don't have the ability to, and maybe that question is hanging over, well, why didn't they get this, or why didn't they show us this, or why didn't they do this? In those circumstances where it's potentially germane to that issue, that is something that is available to us. I can't imagine in every case, I'm gonna tell them, by the way, back in March, I sanctioned them for not giving, this, unless it's real germane to one of the issues that they're deciding, but we'll see if time passes.
All right, so my two rules are about setting action for trial and motion to continue trial. Big change, pleadings don't need to be closed, to set actions for trial. So we're gonna get used to that idea, because as a judge, I look and I go, okay, so I got this motion, I got that motion. The motion of the year is a motion to amend pleading as opposed to a motion to plead. So just understand, they're laughing, because, it's not like we don't notice that if you don't move, continue, if you move, you need to amend. So, they don't need to be closed in order to set you for trial. Well, if you file a motion to set trial, you have to serve it on the judge. So we have. There are many people in the world that think, I have 3,700 cases right now, and you think I know everything that you file. Certain of these rules require you to now send it to us, so we know. So please do that. When you have a case management plan in order, that is your projected trial date. It's not an actual trial date until there's a trial order. There's some differences in setting a trial. If you're just in a proposed trial, and I send out a trial order, my trial order has to be out 45 days before the trial period. If there's a trial order, it's not projected, I have 30 days, which was the old rule, right? The old rule, our current rule, the old rule is 30 days. So understand that you're going to get your orders at least 45 days ahead when you have a case management plan.
And that's when we say there'll be differences within our circuit of how judges are going to do it. So I know, we've talked about this in Collier, we're going to do it immediately. So you have to make sure you know whether
You
you're
need to send out a trial order.
yeah, right after the case management plan.
Yeah, and that's case management plan currently triggers my assistant for to do a trial order. So we're not that far apart. I just haven't decided really what this is going to look like. So I'm keeping my powder dry until we see how this all works. I think a lot of insurance cases, just first party should be on a streamlined track. But I've committed to all my lawyers not to do that, because I think we got our hands full getting these rules implemented without saying, okay, now you don't have 18 months yet a year. So I want to see how this is going to work practically. Do I now need 3 weeks of hearing time and 1 week of trial? I now do 1 week of hearings, 3 weeks of trial. With this, I'm probably gonna have to change some of that. So that's a setting the case for setting action for trial. File a motion if you want to serve us, when you take hearing for motion to continue trial. That's 1.460. Everybody here, raise your hand if you saw a few good men. There's so much in that. What my favorite part really is when Betty Moore objects and the judge says overruled. And then she says, stands up against it, I strenuously object. The new continuance rule says continuances are disfavored and rarely granted. Successive continuances are highly disfavored. So that's what I was saying about a few good men. Like, I don't know, they've always been disfavored in my mind. I mean, my whole career they've been disfavored. If anybody appeared before, I don't remember the judge his name, probably better go unmentioned in Tampa. You walked into his chambers where his hearing room, which the old courthouse was, you were really walking sort of into his office. And behind his desk, he had about 6 feet long and about a foot tall in big black letters that said no continuances, and the O was a red with an O through it. So I mean, that was my introduction in 1992 to litigation. There weren't any other signs that there was else other than this giant right behind it, no continuance sign. So now they're highly disfavored. So think about how that affects us in our decision making. The motions for continuance do not, I get almost every motion for continuance I see now is very general. It starts out with a history of the case and blah, blah, blah. There are requirements of this rule now. Must be filed promptly and the appearance of good cause. The contents, subdivision D has the contents that have to be in your motion for continuance. So don't, like asking for a child to know a vote and a non-binding R, don't just use your 20-year-old form. Read this rule and make sure your motion complies. The easiest thing to do to a judge is have your motion legally sufficient. I won't be excited about it because I will want to address the merits of your motion, but it's not, it doesn't. That's what I do. There has to be a reason for me to violate the law. Please comply with the rule. Lack of due diligence in preparing for trial is not grounds. How do we avoid the need for continuance? We avoid them by saying, for me, any witness can appear by Zoom in a jury. We put them on, people are like, that's not fair. And what about cross-examination? I'm like, in our careers, when we were lawyers, we used to like have a VHS tape that people would have to edit. And we sometimes have to go up with a remote control and just shut off the sound. Or on the actual TV in 1992, my job as the young associate was go pushing you on the TV. I mean, so listen, I'm going to allow you a great deal of flexibility about how to call people. We're going to be so busy. There's going to be less continuances. We're going to have people in the can. You're going to have to take positions, even though you don't want to. You're going to have people available by Zoom. It's your witnesses. Some lawyers have 3 witnesses available to them on a certain issue in the whole world for their cases in our circuit. And you just can't, we can't have, well, they're not available. So if we're going to be efficient, the rule says Zoom, allow remote appearances. The judges now have to talk to each other. Sometimes we have our JAs do it, and we can use a designee. I call it. Judge Keith John, I had one a month ago, and I contact them. I don't, figure out what the deal is. And I think I've had to do it with both of you. Orders, Lauren talked about this in another context, maybe even in this context. If I grant a continuance, the order has to say, granted, the factual reasons why. It has to say where you're moved to, and it has to say whether further activity is allowed. What I have been doing is I've been saying, what do we want to do? And if I've moved you because I'm complex or some other thing that's real, I give you the case management plan, and I say only further activity with the case management plan. If it ain't that, I say you can do these 3 things. What do you want to do? What do you want to do? What do you want to do? And I put them in the order. So understand that's why you're getting that heat from us about exactly what you want to do. You should be thinking about it. Resetting a trial. So it's being rolled. This is not a continuance. It just didn't get reached. It has to say, it has to be set as soon as, when possible, it says. Collaboration with the parties as opposed to just resetting, and I have to give you a new date, and again, I have to say further activity allowed. So understand the rolling and continuance are a different thing. I think that was my 2 rules, and back to Judge McHugh about summary judgment.
All right, and I wanted to touch briefly on continuance, because other than the obligations as far as our order for motion to continue, I don't see my continuance policy changing all that much. Because truthfully, if you look at old 2.545E on continuances, it basically said that they should be rare, and only for good cause. And one of the things that, for some reason, drove a lot of attorneys crazy, that they be in writing with client consent. And so people would call to set their motion to continue, and my judge say, have you filed your client consent form? No. Well, you won't hear it unless your client consent. So you normally get yelled at. And where did she come up with that? Where did that come from? And so finally, I literally had to print that rule and give it to her so that she could read it, and they'd never had heard of it. And so you put that on top of that Chief Justice Kennedy, at the time of the pandemic, also in one of his administrative orders, kind of emphasized strict compliance with 2.54E, as well as the other continuance rules. I think the idea is, and also another thing, once again, with it, Justice came at the time of the last oral arguments in regards to the rule change, and one of the concerns with the bar was, they said, hey, look, we have judges that say, there's no more continuances. Can't continue any cases anymore. He specifically said, that is not what the rule says. That's not what the rule says. No, there are continuances. They're more difficult, and they have to be for good reason. It can't be a continuance because I didn't do what I'm supposed to do. Now, hey, look, your witness ended up in the hospital, your party is, I mean, things happen in life. And you get that, and that's a part of it, but it's not gonna be, hey, you automatically get one continuance, and the second one, we maybe will walk, and, it is real significant reasons why, and it's not, we did take the deposition we're supposed to, we did preserve the testimony we're supposed to, because also, if you look at, all of the orders that are in place, your expert witnesses, if there's a chance they're not gonna be able to be there during that trial period, you were supposed to preserve their testimony some way to have that, in exactly that instance. And so I don't truly see my own continuance policy changing a whole lot, other than now my orders have to be more specific in regards to why. But just throw that in. And I use some of that time because summary judgment isn't all that complex or hard to go over. It's different, but it's been in place now for a while. And actually, I think Mr. Smoot will appreciate this. Jason Gonzalez is actually the one who changed the summary judgment over with Florida Judicial Management Council meeting, had shareholders, attorneys, et cetera, addressing us. And one of the big concerns was we show up at a pretrial or a docket time, and there's a summary judgment that we want to be heard. And the other side, who's opposing, says, well, judge, it's not noticed for hearing. We have to have 20 days in order to do our response, and it's going to take us 2 weeks to do our response, and you can't set that for 40 days. And our trial period will be done by then, so you have to continue the trial, et cetera. And so, based on those type of anecdotes, instead of that, based on when the hearing is, when the response is, the Supreme Court decided, we're just going to make the response due period of time after the motion is filed. And that way, when you show up at our pretrial or docket time, well, there's now pretrial obligations in the pretrial order and in the case management plan as far as when they need to be filed or potentially go away. But if you do show up and say, hey, this is heard, the answer can be, when did you file it? 2 months ago. Okay, I'll hear it tomorrow. Are you guys available? Or whenever it is. And so we can move in a much quicker period of time to hear that immediately without thinking, oh, wait, we've got to wait a month and a half in order for all these procedural issues to take place. So the current rule with that in mind is that summary judgment, A, has to be filed pursuant to the case plan, which has the outline and the dates associated when it can be filed and the time that it can be filed, and that the other side has to respond within 60 days. All right, there's nothing now tied to the hearing time or when the hearing is set, et cetera. It's simply, it has to be filed pursuant to the case management plan. The other side has to respond within 60 days, and then it can be heard at any point after that. And so, once again, kind of a move. I mean, obviously they moved to the federal standard in regards to summary judgment a while ago, but the timing now associated with it is a bit more close to the federal standard. And that's kind of like all of these rules. We clearly are moving more to a federal system that we're talking about and that we're dealing with in regards to it. And so that's really the summary judgment portion of it.
Well, with 3 judges and a lawyer talking, we only went over by a couple of minutes. So, this is our.
No, I'm good.
No, but I had time to decide for questions.
Right.
So, so this is your time. If you have any questions or comment, it doesn't have to be a question.
The administrative order is going to be effectively disseminated to the LCBA, so it's.
Yeah, we can make sure that it gets to everyone. And the good news with it is it will be one administrative order for the entire circuit.
And I'm sure it'll be posted on the website as well.
Right, and it will be county and circuit. And so instead of having to know which individual, judge or county, et cetera, it will be the same.
It hasn't been fully drafted yet.
It's in the process.
The proposal has been fully drafted. It's been presented to the chief judge, and so they're just going through it to make sure that it's in compliance with statute or whatever.
After, but also after, when we put in a requirement that the producing party shall enable is her documents. There's still a lot of ways that don't label or refuse to label is a real problem. I'm wondering if that's something that you can consider.
It's something that can be considered, and I'm just kind of going through all the potential permutations associated with that. One of my concerns is it is going to be for county court as well, which deals with potentially a lot of pro se people. And so the obligation to do anything would apply to everyone circuit-wide, county and circuit. And so I'm a little concerned about a requirement like that, that has that type of ramification, but it's
Could be restricted just to, general, so circuit.
could think about it. Like we said, we're trying to make it one size fits all, which means individual judges, anything that's not covered in there would have the ability to potentially require it.
And I think that's something that the adoption in each judge's policies and procedures. And just so you know, to comply with the new rules, a lot of judges are updating their rules and procedures. So I have new ones that are on my website. I also have updated the frequently asked questions because we have to be in compliance with this. That's a possible suggestion.
And I would say, tell us that. I do it possibly at, privilege reviews. I say I require, privilege log, and the privilege log, reflects the date stamped paper document. Send me paper, don't send me electronic, and I have one on my desk right now about that yesterday. And that's the way that I deal with that as the.
Yeah, same thing. Anytime a big camera review is all there.
I can tell you all where the update rule came from. Most of them still have a book, I think they still publish it. Originally written by the late Henry Trail. I was on the Civil Rules Committee for over 30 years. Henry got PO with something and resigned. He was a longtime chair in drafting subcommittee. They appointed me, and that lasted for 20-some years, and I permanently all. Anyway, the question I've got is this is too broad. I raised it in my column, but I don't know if it's been published, because I'm running too much behind. Is the judiciary feel like they've got the resources to become what I'll call so intimate with the cases? Am I being too obtuse?
No, you're not. And, one of the good things in the 20th is that we do have case managers, which statewide, all the judges don't necessarily have case managers. It will be very interesting because that is a valid question and one that was brought up throughout the inception of these. And one of the hopes is that one of the impetus, and there's been a bunch of impetus to the rule change, was legislators who wanted these rule changes and thought that they were necessary. And some of the discussions that we talked about was, we very well will need additional resources in order to handle these changes. And generally, the legislature doesn't give you something until you act. And so the question is, and are able to show that you in fact do need those resources. So it'll be real interesting with the rule changes, how it does affect us, how many more hearings, how difficult it is for us to handle the caseload. And so whether it's additional judges, additional case managers, additional magistrates, whether we're funded. Now, granted, all of that deals with a lot of, who's in the legislature, what's the economy like, and so I think that it will be interesting. I don't think we have an exact answer.
But tell them about what the Supreme Court says about how many circuit judges we in the 20th circuit.
Yeah, with the Supreme Court, when they came out with their needs study statewide, I think the second highest jurisdiction as far as the number of judges they had was about 4. The number
And
that,
most were 0 or 1.
and the number that the time study said we needed was 13. And the number that the Supreme Court asked for was 7 for this session. 7 new circuit court judges and 1 additional Lee County judge position. Whether it gets funded, doesn't get funded, we'll see. A governor who's about ready to go out of office might have some interest in being able to appoint a bunch of judges, so maybe that makes it, more likely, but it will be interesting. And if you look at the numbers and where they're needed, I mean, right now, Lee County Circuit, and Jeff at least got 1 recently, so he's actually gone from 1 to 2, basically needs almost double of what we currently have. And so the hope is with those numbers, we'll get, 1 or 2 new circuits that will be in Lee County.
We have a lot of questions over here.
Yeah, I know Mr. Scarlett gave an example of that.
Before considering uniform motion calendar to try to set the hearing on motion, don't give the answer, don't give the dates, and play around. So another jurisdiction, has uniform motion. A local motion heard on Monday at what time, you just set it for that time, you have to make time.
Are you talking about uncontested or?
So you're trying to get a hearing on the motion, but you have to get the other side to agree with the date. You can't get the date, so now you fight to get the date.
And I understand, I think like in Miami-Dade and other
Right.
areas, they do have that type of procedure. I haven't seriously considered it yet.
Well, with the duty to confer, it's interesting because you have a duty to confer before you file the motion. And then obviously you're going to have to file a motion or a letter saying that you've tried on these multiple times with the dates and times and that you haven't gotten that. And then when I get that even now, I unilaterally set it by order of the court. That's what I do. If someone tells me that they haven't been able to get a hearing time, that's what I do.
I have whole days where it's court ordered motions, where me, my case manager and my JA go through, I constantly get a list of any case habits over a year old, and I go through and figure out why. And any pending motion that has been heard, we just set it by order. But I think that's a good point, and it's kind of interesting, because you never know how rule changes like this ultimately are gonna affect the way you need to set up your docket, how like Jeff was saying. I have found historically, normally it's not as great as you fear. But it could be worse. I mean, you don't know. And so there might be need to change fundamentally, the way we set up our docket, but I don't plan on doing that until I kind of see what starts coming.
And it may even be set aside, half a day for case management conferences, depending on how many motions are filed. But again, it's too early to tell.
And in 1992, when I was a brand new lawyer up in Tampa, all the circuit civil judges in Tampa had those. And I was, because I was the youngest, I would sign my name, the other would sign their name. But it was motions that would never be heard. It was no response. How do you confer about you didn't respond to discovery and half file motion and certify that you didn't talk about it because they wouldn't, and file a motion and set it for hearing?
Yeah,
Those are the sort of things that I was doing in 1992. A lot of that's not, I think the hope is won't exist or will be sanctioned.
That's what I was just gonna say. By the way, if that does happen, you will get it. You will be paying for that.
Oh,
Applies the motion filed after January 1st.
Yeah.
So there's gonna be a mishmash for a few months, but
Right.
it's motion, 40 days, 10 days.
And I'm really looking forward to everything being grandfathered out. That was just one rule, because I have to look at it, but yes, it will be the old rule.
Yeah, the rules not on this, but for the initial disclosure, you don't anything filed with the court to know if the compliant is that initial witness list to be filed with the court at all, or is it?
No, and what's interesting, the rule actually specifically says don't file with the court unless it is needed for something that's being heard, which truthfully was a previous rule, but I think that's probably a concession to the clerks. Who don't want a bunch of stuff filed that they have to, electronically store, et cetera, but the rule said unless you need it for a hearing or for some purpose, do not file it.
If there's a situation where the defendant filed a motion to dismiss, that is heard within the first case, their initial disclosure would come up, even though they motion. That's not going to make curtail it. They haven't given their answer to her defense. But as I understand it, everybody, even if you have a motion to dismiss, regardless of the motion, you're still subject to initial disclosure.
Yeah, within that rule, like I said, there is always that kind of, has the language that says except by court order. And so, I kind of feel like the ones that I always love is, the motion to dismiss followed or filed simultaneously with the motion to stay discovery, and no one ever says either. And so unless you get a court order that says you do not have to respond to that initial disclosure, then the rule obligates that you file within 60 days of service or joinder. And so I don't think there's an exception to that unless you've got some from the court that indicates you don't have to
The
respond.
question that I had come up, which I don't have an answer for, is the motion to dismiss is no service, no personal jurisdiction, like structurally, fundamentally, you don't have jurisdiction over. And then they have to do all the work to do a 60 days, but I don't think the rule addresses that.
I can't think of it off top line, but at the top of my head, I haven't looked at it in regard to that, and I can't give legal advice, but I sure wouldn't want to waive any
Yeah.
jurisdictional issues by participating in things that potentially
That-
cause an issue.
that's when you can request a court order.
Right.
For something like
Right.
that.
And judges, we have a couple of Zoom questions. I didn't want to miss out on those. One for Judge McHugh. If a case was filed before January 1st, 2025, and discovery was not filed with the initial complaint, before that party now engages in discovery, now that the new rule is in effect, do they have to go through the initial disclosure procedure, or can they file for traditional discovery?
Yeah, I think traditional discovery applies if it was filed previous to January 1, because that rule doesn't apply. What is interesting, and I didn't think about until that was just said, if a party joined after January 1st, I think that party probably would go through the new rule as far as requirements, as far as discovery. I kind of like that because you have to give them everything that you've done previously within 60 days, and they have to, respond. And so that obviously hasn't come up yet, but that is something that I could see happening. And just my thought off the top of my head, without giving an advisory opinion, without hearing arguments each side, that's kind of the way it strikes me.
And then the other question was, again, for Judge McHugh, do you believe that Rule 1.280 subsection F precludes serving production requests and interrogatories with the initial complaint? I assume after January 1st.
After January 1st, I think that's specifically what it does.
Okay.
I mean, it specifically says you must wait till the initial disclosure occurs before you can do any other discovery. So I think it does.
Thank you very much, sir.
Yeah, and so kind of like right now, we get that all the time as far as confirmed to set a hearing, for instance, we get that call and hey, look, we've tried, we've done this, we've done that. Hey, kind of like everyone else talked about, my conferral rule in that regard requires that you actually call. It can't be, I text their brother and I sent 2 emails, and they haven't got back to me. By the way, I started 15 minutes ago. I did all of those in the last 15 minutes and they haven't responded.
Or 3 times within the last 72 hours.
Right. And so what my expectation is that if you weren't able to confer within that motion, or at least the notice of hearing, you're going to have to certify that, you conferred. That's part. If you didn't confer, I will require that you put what you attempted to do in order to confer. And normally it's going to be like that. You actually reach out and try to call them. Emails are great, and a lot of times it makes everything much quicker. But if we're getting to the point where we're not following the rules because of that non-conferral, I want at least a attempt to reach out and say, hey, look, I'm about ready to do this. I'm going to unilaterally, set it. And so on that, I want you to outline what you did do. And I mean, because obviously you can't just not respond and they can never set it. I mean, there's a point where obviously you have to be able to go forward.
Judge Brodie, so you mentioned the requirement for oral conferral. My question is, if there's a motion and it's sent to the other side in advance of filing by email with a request to respond, they respond by email to delineate their opposition, their basis for their opposition. Is that a sufficient conferral to file a motion and proceed without an actual oral?
I think you should still try to pick up the phone before the actual hearing to see if you can limit the matters or streamline them or eliminate them altogether.
So it might satisfy the conferral for the filing, but you want us to follow.
I think I would still like you to talk even before the filing. I don't think email exchange is legally sufficient. Even though it helps, and you may know where you each stand, I think it would still be prudent to pick up the phone and see if something else can be achieved.
And I think what I would say, if you send it, if you agree, because a lot of times I hope you don't have to file the motion. And so you email, they say, oh, yeah, we agree, we'll get it to you, or whatever.
Well, that would be by an agreed order, hopefully.
Or no order at all, you just, or it's not a problem. But I think if you're ultimately gonna file the motion and go forward, I want that discussion, because for the same reason when someone texts me and I start to text back and realize this is gonna take a whole lot more time to type this out and it's not gonna be clear, I should just call that person and go through it and figure it out. To me, the ability to narrow the issue is a lot easier when you talk person to person, and kind of like that federal judge order that just sent that required the attorney to go to lunch who weren't getting along and discuss their families, et cetera. I think it's a whole lot more difficult to be irrational and unreasonable when you're actually talking to someone than it is behind the keyboard. And so I think there is some benefit to actually speaking to someone. And so like I said, this is all new, and I might change my mind in regards to that, but then I think I.
Let's take one last question, then I know it's just about time.
Okay.
You don't have an obligation or in regards to the subject. What happens when time is set for hearing? Unavailable.
Well, let me take this.
Okay.
Kim comes in, Kim is my assistant, Kim comes into my office, let's say time is not about 50 days of done. And, she comes in to me and says, the children are complete. She tells me, just so you know. And I say, okay, what's the issue? And she explains it, and I say, okay, tell them Friday at 8 AM. And she comes back, she says they're not available, tell them 7:30. And I do that until we get set or they can see that they're working at. That's who you got for me. I'm like, I go to the Detroit Free Press, you know, when I was a little kid, you cannot get up before me. And I do not have any time, as you were saying, I don't have time for the hearing set. I am now setting in April, which is the furthest out I've ever been, but I have basically 2 dockets, right, of cases. And I'm not happy about it, but I still, under those circumstances, I don't have anything set at 8 o'clock most days. And so I don't take, we're not available for an answer. And what these rules are telling us is we all have to be less busy because we have to be available. I have to be, you have to be, you'll have to be available. And we have, I had a traveler who legit, not making it up, actual 27 conflicts for a 3-week trial docket. 27 trial dockets around all over the state. Okay, these rules do not envision us just conceding to that. What are we going to tell lawyers that they can't file cases for their clients? But that's what's happening. We're too busy. And not being available for summer judgment hearings, just being too busy at some point.
And I think I would put out there, anyone who's on 27 trial dockets within 3 weeks, there's other issues. That we probably.
Well, all the lawyers in the case told me what's going on. He's a problem.
Yeah,
He
yeah,
goes,
I know.
he's like, have gun, will crack, you know, and that's what he does. And they say, we can't our case.
And so we just sent out an order, setting it, and what I say, it's going here. Unless you guys agree to a different time, that is right around the same time that I set it for. And if you do that, great. If not, you will be here then, and we'll deal with it then. So that's historically how we've dealt with it.
So hopefully that answered some of your questions, and we all look forward to working with you as we navigate this new territory.
Thanks again for being here. Just want to say thank you again to the judges for your time. Great presentation. And if you have more questions, just feel free to reach out.
Thanks to the fire. It's still in our beginning, I love it. Thank you for doing this. Okay, we heard, I've read the rules, written that court. Thank you, sir. I appreciate that.
I can just send you an email instead. Have it in your town.